Well, thank you, Sophie, for a very warm introduction. I've never been very good at pitching myself particularly well, but I think Sophie did a fantastic job. I'm delighted to see 67 people have come back. Clearly, you were all not at the webinar that I did on motions quite recently, or if you are, I'm astounded you've come back for more, so thank you very much. The webinar today is, as per the PowerPoint, it's on proofs. Now, as I'm sure you'll imagine, the topic is absolutely enormous. So I doubt I'll very much scratch the surface. But similar to the motion session, what I've tried to do is frame this webinar as short, sharp takeaways. There are quite a few short, sharp takeaways, but I would suggest that if you take away even half a dozen or so, hopefully that will assist your practice going forward. So if the PowerPoint works, which it doesn't, which it does now, good. So what I intend to go through over the course of the lunch break is preparation for proof, a case analysis for proof, questioning of witnesses, using productions, doing final closing submissions, and then some tips at the end. And I've also got some suggested recommending reading for those that are particularly interested in the subject. So turning first to preparation. Running a proof can be stressful, and if you get any of the preparation bits wrong, you end up just more stressed. So a couple of key points for preparation. Number one is to check your court. Finding yourself driving to Paisley when you should be driving to Dundee is probably not the best start to the morning. So it's an obvious one, but check which court you're in. Equally, check nowadays whether you are attending in person or by WebEx. Again, that would be slightly embarrassing, so double check that. Plan your travel arrangements. If you're unfortunate enough to be using ScotRail, factor in times for your train being late, factor in additional driving time, because the last thing you want to be doing is running into the court building with 10 minutes to spare and starting your proof flustered. So allow plenty of time. Check before you leave home or you leave the office that you have everything you need. So if you are working on written papers, make sure you have every single document you are going to need, copies of every document if the court needs anything. If, like you are now completely electronic, completely paperless, and you're using iPads and laptops, then preload all of your documents. It is very, very rare to ever find a sheriff court that has working Wi-Fi. So the last thing you want to be doing is finding yourself outside, tethering it to your mobile phone to download your submissions or your questions. So make sure your pads and laptops, you have absolutely everything you need downloaded before you leave the house. I've mentioned arriving in time to get yourself into the building, but also to get ready. Touch base with your witnesses as well, so you know where your witnesses are. And very importantly, I would say touch base with the clerk and the bar officer. They should very quickly become on first name terms. So get straight into there, find out who the clerk is, the bar officer, introduce yourself, get on first name terms. Because if you have any difficulties during the course of the proof, it's made a lot easier if the clerk and the bar officer are on your side. So in terms of preparation, that's what I would suggest are the key takeaways. And hopefully that will ensure that at least when the case calls at 10 o'clock, you're starting off on the right foot forward and you have your confidence. So the next point I want to cover is case analysis. It's hard to imagine conducting a proof without any case analysis, but I suppose you would be, to an extent, going in blind. You'd be calling witness after witness and asking them random questions, as many questions as you can, in the hope that when the dust settles, the evidence that the court has written down is actually what you need. And then in submissions, you are hastily trying to pull together whatever argument you can from whatever evidence happened to be elicited. And then cross your fingers and then hope the court decides in your favour. I'm actually getting stressed just thinking about it. So to avoid that, I would suggest a case analysis for every single case. When should you do a case analysis? Well, the session's on proof, but I would suggest a case analysis is conducted right from the very start. Before you even draft a writ, you need to be thinking about a case analysis. So what I would like to do is take you through what a case analysis looks like, why it's important, and give you a starting point to take on how to conduct your own. Now, this is just the way I do it. I think everyone does it in slightly different ways, so take out of this as much or little as you want. So a case analysis, you're looking at three things. You're looking at, first of all, what is the legal propositions you're going to say to the court? So what are the points of law? What is the applicable law in respect of the action that you're appearing? What needs to be satisfied in order for you to succeed? Now, in this case, given the commentary of Sophie's introduction, as you can imagine, I've gone for a personal injury scenario. So legal proposition, there will obviously be a lot more than these, but keeping it straightforward. My legal proposition to the court is the defender had a duty to take reasonable care of the pursuer. Now, it's a legal proposition because it can't be proved with evidence. Second legal proposition, that the pursuer has suffered some loss as a result of negligence on the part of the defender. So these are the points in law that I offer to prove to the court, and I've identified that at the very early stage. What I now need to do is consider the factual propositions. So what are the facts that you need to prove in order to satisfy the legal propositions? So you can tie them together. So the legal proposition, for example, the defender had a duty to take reasonable care. And the factual proposition is at the time of the accident, the pursuer was employed by the defender. So it's an employer-employee relationship, which is why I say gives rise to the employer having a duty to take reasonable care of the employee. So that's how the factual proposition ties to the legal. I need to establish the factual in order to establish the legal. It then also allows me to work out where the evidence is coming from. So where's my evidence? Well, in this case, to establish these, I'm going to be relying on the evidence of the pursuer, and in this scenario, I've got a contract of employment as well. The case analysis at the start, if you do it properly, should flow into everything you should be doing from the point that you're drafting a writ all the way until the point that the sheriff is deciding the case. Right from the very start, you've worked out exactly what legal propositions are going to be required when you get to the proof 9 months to a year or so later. You know what facts need to be proved to establish those legal propositions. Now, to give some examples of how what's on the screen now, in theory, should flow. So if I go back, you can see there's legal propositions and there's factual propositions. In the writ, factual propositions are now appearing in statement 4 and 5, and legal propositions are to a large extent appearing in statement 6. So I've taken my case analysis, which tells me exactly what averments I need in my initial writ. So straight away, I'm ensuring that notice is provided of the arguments that I intend to lead at proof, and I've got the ability to lead all of the evidence that I require to establish those averments. Even at this stage, not only has the case analysis allowed me to work out what my pleadings are going to be, but it provides a framework for then investigating and building the case up as you progress towards proof. It also provides a framework for drafting questions and submissions. So the case analysis at the start helps you draft your pleadings, helps you investigate the case, and then when you reach the stage of proof, which we're concerned with at the present time, it tells you exactly what questions we need to be drafting for our witnesses, because we know what factual propositions we need to establish, and we know what our submissions are going to be, because from the case analysis we've already identified what are the legal propositions and what are the factual propositions. In theory, if we take it one step further, it also becomes the decision of the court. Because when you're framing your legal propositions and your factual propositions, if you've done it correctly, you should have made the sheriff's job very simple, because all they need to do is copy and paste your propositions into their judgment. So any factual propositions in your case analysis, which appear as averments on record, are findings in fact. Your legal propositions, identified right from the start in your case analysis, that form the basis of investigating the case, running the proof, and your submissions, should be capable of copying and pasting into findings in fact in law, or just findings in law. So if you do the case analysis properly at the start, it should just flow right from the start of the action all the way through the proof, all the way into the decision. Now, there's a number of ways to do this. You can use all sorts of diagrams. You can use Excel. There are software available that allows you to pull this together, but Excel works reasonably well. And again, all I've done is 3 columns: legal, factual, and evidence. So straight away, I can see what is my legal proposition. I can then move along to the right, and it tells me every single factual proposition or factual averment that I need proved in order to establish the legal proposition. And then over to the right-hand side, it tells me exactly where my source of evidence is going to be for each individual fact. Now, this will expand during the course of the case, but you can get a rough idea, hopefully, from this, how it all pieces together. You might have one legal proposition and a number of factual propositions that tie into the legal, and each factual proposition might have a number of pieces of evidence. Why do some of you may be thinking that, well, this sounds really time consuming, and yes, to an extent it is, but it is worth it. You are going to appear at the start of your proof knowing that every legal argument you need to make to win the case, you have prepared for. Every fact that you need to establish, you've already identified. You've ensured you have evidence for that, and you've formulated your questions to elicit that evidence. So you know at the start of your proof, and again, it's a bit of a confidence builder, you know that you've covered all of the bases. So very briefly, that is a case analysis. And I would suggest that as much as possible, you try to do a case analysis at the very start. And it will stop you getting to proof and realizing actually there's a very important fact that has been missed and you don't have any evidence for. So hopefully that will assist. But moving on to the proof itself. So you've done all this preparation, you've done your case analysis, you've prepared your case all the way up to proof, and you've prepared all your questions, you've prepared your submissions, you've turned up in court early, you're on first name terms with everyone that's important. Sheriff's important, but don't be on first name terms with the sheriff. And 10 o'clock. So the case calls, that's the best picture I could find on Google, unfortunately. So case calls. What do you do? Well, most of this is an overlap between emotions. Introduce yourself, introduce your opponent. Explain to the court, what is this court action? Is it a personal injury action? Is it an ordinary cause action? Why is it calling? So it's calling for proof. Cover with the court any preliminary business. It's helpful to advise the court how many witnesses you have that day, the expected duration of the witnesses. This is important because you may turn up at 10 o'clock, or sometimes you often do turn up at 10 o'clock to find that you're not the only case to call that day. And the first thing the sheriff will want to know is, how many witnesses does everybody have? How many witnesses do you have? Are they expert witnesses? Are they in the building? And that will assist the sheriff in forming a view of who goes first. So I would suggest, in terms of preliminaries, that is the information you need to provide. Now, you already know how many cases are going to call that day. You'll already have an idea of if anything has priority because you're on first name terms with the clerk. But let's just say you are proceeding, you are going ahead that day. So additionally, beyond witnesses and your expected duration, what else should you provide? Advise the court if there's a joint minute of admissions. If one has been agreed and signed, is it with the court? Does the court have a copy? I find the system used by the court can be slightly difficult for the sheriff to navigate electronically as opposed to the paper copies. So ask the sheriff, do they have a copy of the joint minute? If not, don't worry, because you've got a spare copy. Is there a joint bundle of productions that's been prepared in advance? Again, make sure the sheriff has a copy of that. Are there any motions to be made that morning? Are there any additional inventories or lists of witnesses? Ideally, if there is any motion to be made at the bar on the morning of a proof, you really should have discussed that with your opponent. Find out whether they've got any difficulty with it. Don't accept, yes, they do. What is the difficulty? Can it be overcome? The court will appreciate discussions had before the case calls to resolve any difficulties. So you've got motions for additional inventories, lists of witnesses. Consider any other types of motion. For example, if you have an expert witness and you want the expert to sit in on the pursuers or someone else's evidence, again, that really should be discussed with the opponent. But once you've discussed your preliminary and your opponent has nothing further to add, you then call your first witness, and that is your proof started. Which takes us neatly to examination in chief. I've put introduction there, but I'm not quite sure an examination in chief needs an introduction. I suppose the introduction could be, what's the purpose of examination in chief? Is it a chit chat? No. Is it to get the witness to say everything that's happened in their entire life? No. It is to elicit the evidence that you have determined in advance that you need in order to succeed at proof. It is the witness giving the evidence. So 95% of the talking should come from the witness, but at the same time, you are there to guide the witness through the important parts of their evidence, because the witness is not going to know what is relevant and irrelevant. It is your job to walk them through their own story, but holding their hand. And we'll talk of some of the ways, transitioning, looping, and so on, that you can keep a slight control. List of questions. Should you write out your questions in advance? That's really a matter of personal choice. I would suggest you do. If you write out your questions in advance, not only can you, I suppose there's a number of benefits. One, you can ensure exactly what evidence is going to come out and avoid bad answers coming out for you. Number two, you know that everything you need from your case analysis, you've elicited, because your questions have been drafted on the basis of your case analysis. If you run out of questions, then you can sit down knowing that in theory, you've got everything that you needed from that witness. It also saves you having to take as many notes, because if you're running a proof by yourself and you don't have someone sitting next to you typing furiously, you are going to have to record question and answer. But if you've written down your questions already, you only need to record the answer. It can become difficult, and I do see quite a lot where people focus so much on the questions that they're actually not listening to the answer. I've seen people before get horrific answers, but then just gloss on over to the next question because they haven't heard that answer. They've missed the opportunity of clarifying or cleaning that part up. Equally, I've had people get fantastic answers that are disastrous to their opponent's case, but they've not heard the answer and they just move on. So it helps if you're only having to record the answer, because bear in mind, it is important when you get to the end of the proof and you're making submissions on what the evidence was, that you can be confident that your written record is accurate. So I think list of questions helps in that regard too. I have put here, Google how to win your case, Faculty of Advocates. If you Google that sentence verbatim, you should end up with a speech by the Lord President in March 2018 when he attended the International Women's Day. There's some fantastic advice in that speech. And in respect of examination chief and cross-examination, there was an entertaining example given. So the example that was given, I think from personal experience, was in Glasgow High Court. And an advocate depute was examining what is described as the city's less affluent citizens, who had been possibly regarded as the misfortune of having witnessed a robbery in a local newsagent. So that's the background. Now, the advocate depute asked the less affluent citizen, "What paper did you buy?" And the witness replied, "The Wall Street Journal." So the advocate depute asked, "Really?" And the witness replied, "No." Now, that is two questions and two answers that have been utterly pointless and have taken no one anywhere. And what the Lord President used that example, and he stated, "I can ask the legal profession to ensure that examination and cross are properly prepared in advance and for an end to the off-the-cuff approach which some continue to adopt." And I would tag on the back of that with asking yourself this: why am I asking this question of this witness at this time in this way? If you can't answer those questions, then you probably don't need to ask that particular question. So why am I asking this question of this witness at this time in this way? The way I draft questions, and again, this is personal preference, but what I try to do is do a 3-column. The left-hand column is the question. The middle column is the desired or expected answer. And the right-hand column is the actual answer. Now, I find that's particularly helpful. One, because once you've drafted your questions and you're preparing for the proof, you can read that question to yourself. And if you are able to answer that question in a way that does not give you the desired answer, then you can rephrase the question, and you can keep rephrasing it until you ask yourself the question and the only answer you can give is the desired answer. How do you know the desired answer? Well, you should have precognitions or statements or other documents that will tell you what the answer is going to be, because if you don't know what the answer is, again, don't ask. Ask safe questions at all times. If you don't know what the answer is, don't ask, because the witness will bury you. So you know what the question is going to be. You know what the desired answer is. And the desired answer is hopefully the answer that is going to support that factual proposition. Reflecting back to a moment ago, when I said in experience, people sometimes don't listen to the answer, this is where this comes important, because if the witness does not give you the desired answer and you have picked up on that, you can follow up questions until you get the desired answer. So if you think of a food poisoning claim, where your statement has a number of items of food and drink that someone's consumed at a restaurant or on holiday or whatever, you've got them as your desired answer. If you're recording the actual answer, you can very quickly compare and contrast between the desired answer, and if there's something missing, you know to follow up questions. So again, that ensures that you're fully exploring that question until you've got exactly what you need before you move on. And again, I think it saves note taking, and it ensures that you're really just recording the answer as opposed to the full question. Leading questions. Well, it's examination in chief, isn't it? You don't ask leading questions. Well, you can. Leading questions are, you can ask leading questions. The difficulty with leading questions is they don't carry as much evidential weight because it's not coming from the witness. The witness is just agreeing with something you're putting to the witness. But there are times where leading questions are perfectly acceptable. For example, if there is a huge part of the evidence that isn't contentious, There's no argument about these particular sequence of events, but it needs to be covered. So the court has this evidence, and perhaps it's important for the court to understand the background. You can discuss this with your opponent in advance. You can say to your opponent, okay, the 15 minutes before this road traffic accident, that doesn't seem to be in dispute. You're happy if I lead the witness through that? And you can just take the witness through that with statements, and the witness can just nod and say yes as you go through. And it's very efficient, but seek your opponent's permission first so they don't object. Transitioning. So going back to what I said earlier about holding the witness by the hand and taking the witness through their evidence. Transitioning is where you direct the witness to a particular topic. So you say to the witness, I want to ask you about this, or I can direct your attention to that now, or we'll stop talking about this. I'd like to explore this aspect with you, or we can discuss this now. It's letting the witness know that we've moved away from a particular chapter, and they know there's another specific chapter they want to talk about. It avoids the awkward question of what happened next, which is a very dangerous question because you never know what the answer could be to what happened next. So that is transitioning. Looping. Looping is where you exercise an additional degree of control of the witness. And looping is where the answer is echoed in your next question. So for example, you ask, what time did you get up? The witness says 8 o'clock. You then ask, how did you feel at 8 o'clock? You're tying the witness in very, very carefully. What time did you get up? If you just asked, how did you feel? There'd be no context in terms of time, in terms of that answer. So if you want to focus specifically, what time did you get up? 8 o'clock. And how did you feel at 8 o'clock? And it's a high level of control, even in examination in chief. Alternatives. Again, this is, I suppose, a leading question. Another example of leading question that is acceptable if there are a finite amount of choices. When you encountered the victim, were they conscious or unconscious? That's not a leading question. There's one of two choices. Was it the weekday or the weekend? Again, not a leading question. It's one or the other. Were the traffic lights red, amber, green? There's three choices. It's got to be one of the three. That isn't a leading question. That's perfectly acceptable. Content. Again, I suppose this is similar to transitioning. It's letting the witness know that you want to talk about a specific aspect. So uses of phrase in relation to, with regards to, in respect of, indicates to the witness exactly what direction you want to take the questioning to. If you have a concern that the question is leading, for example, if you asked to what extent, or something along those lines, if there's a concern that it's a leading question, just add if any at the end of it. You're leaving it open. So just the words if any at the end of that question leaves it open. Putting the other side's case, it's a slightly pompous way of doing it, but I suppose it works. It might be suggested to you. It's important to give your witness the opportunity to deny the opponent's propositions. So it might be suggested to you that you're absolutely talking rubbish today. It might be suggested to you that you're lying. What would you say to that? It's usually best doing at the very end. It leaves you off as a high. It brings in your opponent's cross-examination at a slight disadvantage, because the whole point of your opponent's cross-examination might be to put to them that they're lying. They've already put it in front of the court that that they're not lying. But you have to do that, putting the other side's case to you. So that is examination in chief. I would suggest you Google how to win your case, Faculty of Advocates. It's the only website I could actually find a copy of the speech, but it's well worth reading. It applies equally to civil and criminal, through first instance through to appellate, and I would say examination in chief and cross-examination as well. Cross-examination. What's the purpose of cross-examination? Cross-examination is to weaken or destroy evidence that is inconsistent with your position. If you say one thing, your opponent says the other, this is your opportunity to try to weaken and destroy that witness's evidence that is inconsistent with your client's position. Equally, it's your opportunity to challenge that witness as either an incredible witness, so they're lying, or an unreliable witness, so they're doing their best to tell the truth, but they just can't remember properly. If you can't think of one of those two purposes for any specific witness, take a step back and consider whether you need to cross-examine them at all. Quite often I see examples where people cross-examine where I'm watching and I don't actually quite see the point of it. It doesn't seem to achieve anything. It just seems to be, I must cross-examine, I must fill this blank. You don't. You can turn to the court and just say, no cross-examination, I'm fine, thank you, my lord. Don't underestimate the impact that has on the bench, because essentially what you're saying is my opponent's examination in chief of his key witness has done so little damage to my case, I actually don't need to cross-examine at all. So think very carefully, do you need to cross-examine? But if you do, if your opponent's witness has produced evidence that is completely inconsistent with your position, you should cross-examine. Equally, if you're saying that that witness is incredible or unreliable, you should be cross-examining. What is the approach of cross-examination? Someone said to me once, it's like the special forces. Prepare in advance, get what you need, get out. Cross-examination is great fun. It's sometimes less stressful than examination in chief. You're putting statements, you're not asking questions and giving free rein to the witness. But equally, a lot of damage can be done because you may find yourself cross-examining a witness that is perfectly live to the fact that you are not on their side, that you are putting forward a position that is contrary to theirs. Don't underestimate them. Lay witnesses can be particularly astute to the court's process. They've seen enough of telly. They know what to expect. So prepare in advance. Think very carefully about their position, what their evidence is going to be, and what do you need to achieve. Write your questions or your statements of cross-examination in advance. Stick to those points. And once you've got what you need, sit down. Some of the worst examples where it has all gone terribly wrong, where someone has achieved a fantastic outcome in cross-examination and then has followed up with a question of, well, how do you know that? I'm trying to think of an example I had. It wasn't me, I should caveat. I think from memory, this is going back a few years, but I think from memory, the cross-examination was all about this witness's recollection of an accident from many, many years ago. And in cross-examination, they got from the witness, well, it was many, many years ago. You have not been asked about this since that time. You weren't asked to put anything on paper. You're recollecting everything from today. And there was acceptance across all of the statements. Now, at that point, what the lawyer should have done is just sit down. They'd achieved everything they needed to say to the court, well, look, it's been 3 years. They didn't write anything contemporaneous down. They've never been asked this again until today. The court can find this an unreliable witness, or at least have can find an unreliable witness. Where this went wrong was at the end of those statements, and the witness says, no, I wasn't writing anything down. No, I'm recalling it now. The lawyer asked, well, then how can you be so sure of this accident date? And then the witness turned around and says, well, it's my anniversary. I'd never forget that date. And the whole cross-examination was now scuppered. So Ask your questions. Don't get carried away. When you've got what you need, get what you need and get back out. Sit down. If in doubt, sit down. Cross-examination is not the chance to give the witness another opportunity to give their favourable evidence again. They've had that opportunity in examination in chief. You shouldn't be giving them the opportunity to reiterate their evidence. How do you stop them reiterating their evidence? Statements, not questions. Examination in chief, who, what, where, why, how. Open questions designed to elicit the story. Cross-examination should be propositions, statements that you have prepared in advance, and all you want is a yes or a no answer. Ask yourself in advance the proposition. Can you answer that in any other way apart from yes or no? You should not be giving them a chance to explain. If they start to explain, you can interrupt them. You can say, well, no, you've answered the question. If my friend wants to explore the points, they will do so. Your opponent can re-examine if they want to explore these in more details, but your proposition, it's a yes or a no. 95% should be coming from you, 5% from the witness. Just propositions, yes and no. Putting your case to the witness. You can use the, I put it to you, if you want to. It's a bit cringeworthy. And also bear in mind, I put it to you that you're absolutely lying and this accident was actually all of your fault. What do you think the answer is going to be to that? It's clearly just going to be a, well, no, that's not right. You're talking rubbish, Mr. Lawyer. So what I would suggest is, instead of the, I put it to you, frame your case into propositions. Take your case and put it into short, sharp propositions that you can just put to the witness. You're more likely to get the witness to have some sort of mistake or a little concession by doing that than a long-winded, I put it to you. Prior statements. Right, okay. Witness gives evidence and says something in chief that is inconsistent with something they've said in the past. How do you deal with this? The answer to that is carefully and with a straight face, with a poker face. You can't let them figure out where you're going with it. Now, the three stage of doing this is recommit, validate, confront. So let's say my opponent has a witness who says, I witnessed an accident because there's an accident in a car park and I witnessed it. I was there. I saw this and it was all the pursuer's fault because I was there at the time of the accident. I saw absolutely everything. But I know shortly thereafter, there was a statement taken from the HSE. And in that statement, this particular witness said that at the time of the accident, they were in the staff room or whatever. They turned up at the car park, everything was over, they witnessed absolutely nothing by that point. So recommit. So recommitting in cross-examination is saying to the witness, in your evidence in chief, you told my friend you were in the car park at the time of the accident. You need to get agreement on that. You need them to recommit to that answer. Move on to validate. If you cast your mind back to the time of the accident, I'm right in saying the HSE took a statement from you. Yes, they did. Well, you knew it was important. That's why they were there. You knew it was important to give them an accurate version of events. Yes, I know that. And they took that from you, what, 30 minutes after the accident? Correct. Okay. Now, these are fairly simple questions. Hopefully your witness doesn't see where you're going with this. The purpose of this is a statement was taken from you shortly after the accident. You knew it was important. It's the HSE, so you're going to tell them the truth. You're going to make sure it was accurate and it was contemporaneous because it was taken 30 minutes after the accident. Hopefully they don't see where you're going yet. Now, if you get that far, the third stage is confront. Take them to the document and highlight, it says here, you told the HSE at the time of the accident, the staff room, and you're right in the car park after the accident. That's correct, isn't it? Yes. Now, sit down. You've done your job. You've already highlighted to the court that a particular aspect of this witness evidence was wrong. They have misremembered. You've achieved what you need to build up a case of saying to the court, this is an unreliable witness. Do not at that point ask the witness to explain. You got it wrong, correct? Yes. Well, how do you explain that? Because they will try to find some way of explaining it. Recommit, validate, confront, sit down. Using documents not lodged in cross. Are you able to do that? Yes, of course you are. Paragraph 16.25 of McPhail. Yes, you can do that. First of all, you need to consider, is it a document that's been authored by the witness? So obviously a statement giving in the past, that's quite a straightforward one. When you start moving into other documents, for example, a social media extract which is inconsistent with an answer, slightly murkier waters there, but I'd still say it can be done. Consider the triggering answer. They need to give you an answer that you can say to the court is inconsistent with the document you're now going to produce. So again, if you've got a document up your sleeve that's not been lodged and it's up the sleeve, ready to go for cross-examination, you need to make sure that the questions you've prepared will force that witness to commit to the answer that you know is inconsistent. And at that point, if they commit to that, you can use this document to challenge their credibility. But it has to be their credibility. It can't be their reliability. It has to show that they've lied. Consider, however, how you're going to establish provenance. So a letter that is written by that witness and signed by that witness and dated by the witness is easy running. But what about things like Facebook, for example? You will find difficulties in different courts. You might have a sheriff that looks at that and says, oh, I know exactly what Facebook is. I'm looking at the screen. I know that's been a screenshot of someone's profile page. Equally, you can have a sheriff that says Facebook, ? So think about how you're going to establish the provenance of the document that you're using. And then the final thing I want to talk about with cross-examination. How do you deal with inconsistencies? So you could have inconsistencies because there are just different interpretations of the exact same evidence. The evidence, there's no dispute about the evidence. It can just be interpreted in different ways. So put your interpretation to that witness. Seek concessions that it's possible. You'll either get from the witness that, yes, that's possible, that assists your case, or you'll get a dogmatic witness that will just refuse to agree with anything you're suggesting. Which again is helpful for your case because it shows that they are a weak witness for your opponent. Lying witnesses. What do you do with a lying witness? Far from shouting at them and calling them a liar. What do you do for a lying witness? Okay. Lying witnesses are they do one of two things. They've either come up with a story in advance and they've rehearsed it while walking the dog, and they're ready to give you this fabrication. If it's one of those, the best way to do is just keep asking them questions, because they will have only prepared this story so far. So if you keep asking questions and digging down deeper and deeper and deeper. So when they say, I was there because I went to a shop. Oh, what shop did you go to? I went to Asda. What did you go to Asda for? I went to buy bread. What kind of bread did you get? If you keep going and going, you're forcing them to invent more lies. And they're inventing them on the fly. And you're more likely to get, for them to be caught out. So what was described to me is follow the lie. Keep putting them on the spot. Keep finding more and more detail, because eventually they'll just run out of answers. Equally, it applies if they're making it up on the spot. If you get the dogmatic witness, seek reasonable concessions. So a road traffic accident where they say they're doing a particular speed. I was doing 28 miles per hour. not 29, not 27. Possible you were doing 27, 26. If they refuse, again, it damages their credibility and reliability because they're not making reasonable concessions. So I would say in terms of inconsistencies, those are your avenues. Now, after cross-examination comes re-examination. Re-examination is restricted to topics raised in cross. So if it hasn't been raised by your opponent in cross, you can't explore it in re-examination. Equally, be conscious that if you have crossed and your opponent has now had a panicky moment and realized there was something they probably should have explored in examination in chief, but they didn't do it, be ready to object if they start exploring it in re-examination. Equally, you may have questions on cross-examination you have prepared to deal with something that you think they will explore in examination in chief. But if they forget to do it, don't ask the question, because they will be able to explore it in re-examination, and that whole aspect of their evidence has not been led. If you explore it in cross-examination, you're opening the door and letting them cover it. So it's restricted to topics raised in cross. Leading questions, certainly not permitted. It is open questions to clear up any confusion. But I've said here and in red, never ask a question you don't know what the answer is going to be. That applies for chief and cross. Re-examination, generally speaking, should be few and far between. You'll need to do that. And if you are doing it, it's really just one or two questions. You know, saying to your witness, you said in cross-examination, this, or for example, in cross-examination, it was put to you that you'd spoken to your sister about this accident. It might be suggested that your recollection today is your sister's and not your own. Exploring it in that aspect is clarifying something. It's not really going back into more information. So it really should just be one or two questions. Using productions. First of all, ensure everyone's with you. Don't be too quick off the mark. So, my lord, I want to take the witness to 5.1 of process. Wait. Ensure the witness has 5.1 of process and ensure the court has that. Whatever the document is, highlight to the court and the witness how you're going to navigate it. Are you using page numbering, paragraph numbering? Where is that? Is it at the top right or the bottom center of the page? Just so everyone's on board. Do you have that document? It's going to be page numbering I'm going to use. You'll find that at the bottom of the page. And then take the witness and the court to the page or paragraph numbering. So ensuring everyone is with you. Lay witnesses, walk them through it, talk it into the evidence. Having a lay witness say, right, this is a Google map, can you point to where you are, is utterly pointless if they're facing you. They need to be pointing to the court. The sheriff needs to see what they're pointing at. You also need to talk it into the evidence. So, can you point to where you were at the time of the accident? Oh, I was here. Okay, for the benefit of the court, you are pointing to the area to the right of the red car that we can see in the top right hand of the picture. So talk it into the evidence. Expert reports. If there's nothing in an expert report that's going to be objected to, for example, if you've got pleadings to support all of the expert's report, have the expert adopt the terms of the report as their evidence. So establish their credentials, what entitles them to give opinion evidence, and just say, are you prepared to adopt the terms of your report as your evidence today? If they say yes, their report now becomes evidence. What you can then do is, with your questioning, just explore certain aspects that you feel need a little bit more detail. So I'll just take you to paragraph 44 then, and we'll have a chat about this. But again, going back to the red font, only do it if you've spoken to that expert and you know what their answer is going to be. If you don't know what their answer is going to be, don't give them the option to elaborate. So you've done all that and you get to the end of the case or the end of your proof. Your submissions. Again, they should be prepared right from the very start. You've done your case analysis. Your submissions can be prepared from the case analysis. Submissions are basically, what do I want to say? And submissions tell us in advance what evidence we need to say it. So what you should be doing is writing your submissions before you even write the questions. Because if you write your submission and you're happy that if you speak those submissions to the court, you've ticked off all the legal and factual propositions in your case analysis, you've got all the bases covered in order for you to succeed, you will now know what questions you need to ask. So always draft the submissions first. Written submissions. Excellent if the court asks for written submissions. If the court adjourns and asks for written submissions, then fine, you provide written submissions. If you get to the end of a Wednesday and the court says, right, okay, we'll stop there. If I could have written submissions for tomorrow morning, again, fine. Shouldn't be a problem for you, because if you've drafted them already, all you're having to do is read through them and make a few tweaks. Again, if you've drafted your submissions before your questions, and you're only asking questions that you know what the answer is going to be, and the answers are then exactly what you're expecting, when you get to the end of the proof, you really shouldn't, in theory, need to do much to your submissions. But you read through them, you make through a few tweaks. But if the court ever says written submissions the next morning, you should be in a position to do that fairly easily. But what happens if you've got written submissions in front of you and the court expects submissions immediately following the conclusion of evidence? Don't read them verbatim. You're using them as a speaking aid, and use them as a speaking aid. Don't hand it up to the court and then everybody reads them together, because just like what I said in motions, that's just going to irritate people. The court can read. So use them as a speaking aid. What should the structure of submissions be? This is again very similar to the motions. Start with, what is your motion? So are you looking for absolvitor? Are you looking for dismissal? Are you looking for payment? What is your motion? Identify to the court what are the issues. So you can say to the court that in my submission, these are the key issues in the case. These are the questions for the court. After that is a good point to deal with any objections. So if any of the evidence was objected and heard under reservation, you will now need to deal with that objection. Going forward, you're not regurgitating the evidence, which is something I see quite common, particularly if you've got a short proof. The court has just heard the evidence. It doesn't need to hear it again. Submissions are your opportunity to extract the key parts of the evidence and explaining to the court why, if the court accepts this key components of evidence, why this entitles the court to make the findings in fact and the findings in law that you need to succeed. So what I would suggest you do is take the court through the legal and the factual propositions. So take the court through the legal propositions. So going back to the case analysis, the example, I can say to the court, well, my lord, the first issue is the existence of a common law duty to take reasonable care. So that's the first issue the court needs to determine. Now, the court heard evidence from the pursuer that he was employed by the defender at material time. The court was taken to the contract of employment. That wasn't contentious. The court could see that the employment contract covered the period at the time of the accident. So taking that together, my lord, in my submission, the court can make a finding in fact that at the time of the accident, the pursuer was employed by the defender. If the court does so, the court can conclude that an employer-employee relationship existed at the material time, and accordingly, the defender had a duty to take reasonable care. So you are highlighting the key parts of the evidence, tying it into what you say the findings in fact can be made by the court if it accepts that evidence, and then what's the legal position that flows from that, and then do that for each and every proposition that you've identified in your case analysis. Highlight to the court, if your opponent did not challenge evidence, the court is entitled to draw some reasonable inferences in your favor, and you should always conclude with a short and persuasive conclusion that ties everything together before renewing your motion. Now, I appreciate we've just turned 2 o'clock, so before people disappear, I'm going to be about another 5 minutes. So renew your motion. Remember to prepare for and be ready to move for expenses and certification. Even if you're not entirely that confident you'll win, always prepare what you're going to be moving for in terms of expenses, certification, so on. Before I get to tips, other documents you can use in submission. Proposed findings and facts. There is nothing stopping you from drafting out a document in numbered paragraphs where you say, these are the proposed findings and fact that you want to appear in the sheriff's decision or judgment. You're essentially just doing the hard work for the court. You're handing that up and saying, my lord, here's proposed findings and fact that I say the evidence justifies. Highlighting the proposed findings and facts, does that come from the record, the joint minute, notice to admit? You can provide the court with evaluation of claim and appendices. So my tips, prepare a case analysis. Hopefully I've drilled that home. Draft your submissions in advance. Draft your questions from your submissions. Don't know, don't ask. Attend proofs and watch. You can watch the Supreme Court, the Inner House as of today. I think it's today. You can watch online, so watch as much as you can online, but with the caveat, you can learn from others, but be yourself. Don't try to be the next Donald Finlay. You won't pull it off unless you can do the pipe, okay? For those that are interested, these are the 3 key books I recommend. Monkman, Technique of Advocacy, Devil's Advocate, The Golden Rules. Just to prove the point, I have 2 here. Short, simple, slightly entertaining reads, particularly Ian Morley's The Devil's Advocate. And at that point, Sophie, do we have a...
Yep, thank you very much for that, Robert. That was incredibly helpful.